heard of Hedley Byrne and Heller, and maybe you've heard, oh, it was a significant decision reached by the House of Lords. And maybe you've been told that it impacted both English contract law and English tort law. But you're not quite sure what we mean when we say it was a significant House of Lords decision. And you're not sure exactly how it impacted both English contract law and English tort law. Worry not, in this video, I will explain those things. Hi, I'm Denise and you're watching Law with Denise. Before we get started, if you're not familiar with the facts of Hedley Byrne and Heller, please watch this video in which I summarize the case. And if you're looking for more details about what was discussed in the case in the House of Lords, please watch this video. The links to both videos are in the description. Now let's begin. Let's start by looking at how the case or the decision impacted English tort law. Now, until Hedley Byrne and Heller was decided in the House of Lords, the standing precedent was Candle and Crane. In Candle and Crane, the claimants had not been able to recover pure economic losses because they were not in a contractual relationship, nor were they in a fiduciary relationship with the defendants. The court decided that if a claimant was not in a contractual relationship nor a fiduciary relationship with the defendant, they could not recover pure economic losses in English tort law. That was the law until the House of Lords created an exception to this general rule. That exception was that in some situations, even if the claimant was not in a contractual nor a fiduciary relationship with the defendant, they would be able to recover pure economic losses in English tort law. The House of Lords outlined that in order for this exception to the general rule to be applied, the Hedley Byrne principles would need to be met. They are that the claimant and defendant were engaged in a special relationship, that the defendant voluntarily assumed responsibility towards them, and that the claimant relied upon the information or advice given, and it was reasonable for them to do so. If you need to find out more information about the Hedley Byrne principle and how the principle has been applied in the courts, I do have several videos on this. The links to them are in the description. Now, let's explore how the decision impacted English contract law. So in addition to having an impact on cases which involve parties who had not entered into a contract, the House of Lords decision in Hedley Byrne and Heller impacted cases which involve parties who had entered into a contract. But we're speaking here of cases which involve one party saying, I'm only in this contract, or I only entered into this contract because of misrepresentation. And it involves the claimant saying the defendant is guilty of using misrepresentation to induce me into this contract. Now, before Hedley Byrne and Heller, in such situations, the claimant would need to demonstrate that the misrepresentation they are talking about is or was a fraudulently made misrepresentation. But in Hedley Byrne and Heller, their lordships said this was actually incorrect. You see, this understanding that we had of the law came from a misunderstanding of the precedent Derry and Peake, according to their lordships. Now, until their lordships clarified this in Hedley Byrne and Heller, it was thought that Derry and Peake had told us that in such situations, the claimant would need to demonstrate that the misrepresentation in question was fraudulent. But their lordships said, no, we don't need to do that. It is sufficient for the claimant to demonstrate that negligent misrepresentation was what induced them into the contract. So that is how the case impacted English contract law. Is it still relevant today? Well, in most situations involving misrepresentation, we do not turn to Hedley Byrne and Heller. We do not turn to the common law. We turn to the Misrepresentation Act 1967. However, if we have a case involving misrepresentation and the claimant argues that the misrepresentation was not made by the defendant but by another party, then it is not the Misrepresentation Act that we turn to. We actually turn to common law. Thus, Hedley Byrne and Heller remains relevant. So there you have it, a brief explanation of how Hedley Byrne and Heller impacted both English contract law and English tort law. I hope that was useful. Thank you for watching, and until next time, please remember to like, share, and subscribe. Bye-bye.